Good afternoon, everybody. Welcome to our, what is today? Welcome to our January 28th Board of County Commissioners work session. Just a reminder for anybody who might be with us in the audience or listening online, our work sessions are for informational purposes only. This is an opportunity to receive information, have a discussion amongst commissioners, so there will not be public comment specific to our work session. Anybody who has public comment they would like to provide is welcome to join us at our 5:30 business meeting during the general public comment time. And with that, I will turn it over to Katie to introduce our guests.
Thank you, Commissioner. Katie Fitzgerald, Criminal Justice Coordinator. I am just providing a brief introduction to your work session today. This session is the next step in our journey of providing elementary and middle school truancy services and transitioning more of those services from the Center for Supportive Communities and the Support Ed program to in-house with criminal justice services. So this started last year in your budget process. You all set aside the $150,000 that previously had been allocated to CSC. That had been set aside into your contingency budget for further discussion around revisiting what a different model of providing those services could look like. Since that time, we came to you in December, on December 3rd, to request that part of that money be allocated to CSC for them to finish and complete this current school year providing services, and indicated at that time that we would be back before you with a proposal of what services or a program could look like for our elementary and our middle school students. So I want to be clear too, we're just talking about those age groups. We're not talking about truancy for our older high school students. That service is provided by O'Connell Children's Shelter. So to date, what is left kind of on that line item after the December 3rd session or meeting is $87,500 for the remainder of 2026. The session today will be led by our Criminal Justice Services Youth Services Division staff, and they will be presenting an overview of their proposed program and also some kind of grounding in Kansas law around truancy. A lot of the history of these services was provided in your AIR, and so I don't think we're going to spend a lot of time on that. And then they'll provide more of the overview of what they proposed and kind of how they got to this proposal and what we foresee as next steps. Our partners for this, in addition to our youth services staff, are Building Peace, our district attorney's office, and the Douglas County Public School Districts. Many of those folks are here with us, and I know we've done outreach to the other school districts who may be online potentially. So with that, I will turn this over, I think, to Lee to
Katie,
pick the next
I
one.
had a question. By the remainder of 2026, you're kind of talking about the fall semester, if you will.
So I think that's part of what we will talk about when we, there are some staff costs that are part of, that you'll see in the presentation. So it's, the services would not start, we would not propose launching this until the beginning of the next school year, but there will be costs incurred prior to that in order for the staff, for the department to be prepared. But yes, in general, the last half of the school year, the last half of the calendar year. So.
Will we introduce everybody that we have here? Yeah. Okay, thanks.
Yes, thank you for that segue. So my name is Lee Hausman. I'm the Assistant Director over Douglas County Youth Services. And my colleague Kate Holman and I will be speaking to you today about our truancy proposal. We're here with our Director, Pam Wiegand. And then can I just have you guys introduce yourselves on the way down?
Okay. I'm Dave Mathis with a mediator with Building Peace.
Hi, I'm Elizabeth Zay. I'm one of the new prosecutors here at Douglas County, and I do the high school truancy.
I'm Katie Britton. I'm a chief assistant district attorney. I've worked there for 18 years, 8 of which were sync. So I have a little bit of background on the history of the truancy stuff. Currently, I am doing elementary and middle school truancy.
Okay, thank you, everyone. And I'm going to hand this over for Kate. She's going to talk about the Kansas truancy law for a few minutes.
Fantastic. Yeah. Oh. Good afternoon, commissioners. In the state of Kansas, any child aged 7 through 17 must be enrolled in attending school. There are a few exceptions. If a child is under the age of 7 and enrolled in school, they are subject to the compulsory attendance, meaning that they must be attending school. The other exception is any child age 16 and older can legally sign out of school by a parent or guardian. In Kansas, a child is considered truant if they have at least one unexcused absence on 3 consecutive days, 5 unexcused absences in a semester, or 7 unexcused days in a year. Whichever occurs first, this is referred to as the 357 rule. For example, USD 343 Perry Lecompton, they define an absence as 1 or more hours for elementary school or 1 or more class periods for middle and high school. So if a student is unexcused for at least 1 hour or 1 class period in a single day, that day can count towards the 357 rule. Required school notification process. So Kansas statute outlines mandatory procedures for school officials to address potential truancy. Truancy is a term defined as a threshold of unexcused absences, and schools have a legal responsibility to report truant students to the state of Kansas or the governing entity. Here in Douglas County, it's reported directly to the Douglas County District Attorney's Office. Keep in mind that all absences negatively impact the success and should be immediately addressed. Before a truancy referral can occur, the schools must legally conduct a required process. They have to give the parents written notice that the child meets truancy criteria, and they have to have that documentation filed with the parent. They usually send out a truancy warning letter and notification with the attendance. Continued failure, if the child continues to have unexcused absences, then there'll be a report made to the Douglas County District Attorney's Office. Next slide is truancy referrals. So here's a review of the truancy referrals for the 2024-2025 school year, and also for the current 2025-2026 school year for your review. I keep this document. It's a living document. It's updated daily, weekly, and it's provided to all partners with weekly updates.
I have a question. How many school districts are included in those numbers?
So we serve all of Douglas County Public Schools. So that would be USD 497, USD 343, which is Perry Lecompton, USD 348, which is Baldwin City Schools, and USD 491, which is Eudora Schools.
And the other 3 school districts that have a small number of children in Douglas County in the Wellsville School, Shawnee Heights, and Santa Fe Trail.
We don't serve those schools because they'd have to have an arrangement with the county to do that.
They're mostly housed out of county, but we have students then that would fall under these rules, even though they're in a different school district, or would they be reported elsewhere?
I believe they would fall under school district rules, but Commissioner Kelly might know more. Okay. Yeah, so it's up to the district.
So Kate, you're telling me that 24 middle school students in the year of 2025-26 met the 357 rule. Is that correct? Or that's just how many were referred?
2025, yes, we have received 24 referrals.
So there may be students who are legally truant by the definition, there is a requirement of the school district to report it, but they haven't been referred to criminal justice services, or they haven't been, I mean, it sounds like the DA's office is notified of that. And it's only 20. I just want to make the difference between notification to the DA's office of it versus referrals.
So that would be actual referrals that have been made to the district attorney's office this year.
25 met the 357 rule this year.
24 met. the
24.
25. That's how many that have been referred.
Okay.
How does a referral actually, how is a referral submitted into the system?
Thank you. Good question. So when the school, the responsible person at the school, recognizes that the student meets truancy criteria, they have to meet the 357. That person sends out a truancy warning letter to the parent, also with the attendance attached. And then that family has the opportunity to come into compliance and resolve those kind of unexcused absences within a certain amount of days. The school will attempt to handle that. Sometimes I even assist the families to continue to try to solve that when I get a referral. However, if the child continues to meet truancy criteria and they're having continued unexcused absences, that's when the school does file the official 1006 form with the truancy warning letter and the attendance, and that goes directly to the district attorney and CJS truancy.
Did I hear you correct that 1 hour can count to the 357 rule? Okay, and so we have 24 that met that criteria?
That's how many that have been referred.
Yes.
This current school year, we've received 24 middle school truancy referrals.
I think what you all are picking up on is that it's wildly underreported to us. We don't know about it until they give us the information. And it is, I would say, the standard that when we open up the attendance and look at what it is, they've met 357 plus the letter plus an additional absence many times over.
Are you tracking, trying to figure out how to say this. What are you tracking? What are you tracking? What are you tracking is what I'm saying.
I mean, Commissioner, they can't track anything until they get the referral.
I know. So when you
So
receive a referral, I guess what I'm asking is, what are you looking at for each individual referral? I'm
Well, why don't
trying.
let's go through the presentation and you might learn a little bit more about
Okay.
the process.
To get the proposed background information. Sorry, the proposed background information. So we started in June of 2025. We were tasked with this opportunity to just create a truancy program here in Douglas County. We started by reaching out to our neighboring jurisdictions, Shawnee County, Wyandotte County, and Johnson County. In October, we were able to attend the 35th Annual National Dropout Conference, which was very helpful to collaborate with others and network and learn what other schools and jurisdictions are doing across the country. Excuse me. We were able to visit with Johnson County. Their district attorney program refers cases to their Project SKIP. So we were able to head over to Johnson County and sit and observe the hearings with the Project SKIP program. We've partnered with Building Peace. We have an established relationship with Lyle and Dave, and who have practiced restorative justice in the community. We have met with them and offered to have collaborative ideas about truancy prevention programs. So we've reached out to them. We've also reached out to Mr. Dakota Loomis, the district attorney, and informed him of what our next steps were. And we also met with USD 497, who is the main school that we serve, and kind of let them know what our intentions are. Excuse me, the next slide is the truancy referral process.
I believe you just said you met with several individuals and let them know what your intentions are. Do you have a slide for intentions, or do you want to let us know what your intentions are? Okay, all right.
On June 25th, 2025, CJS, DCF, and CSC met with the district attorney's office to kind of address the truancy referral process. And we reached an agreement to kind of streamline the referral approach, kind of make it more streamlined to have the referrals directly sent to the district attorney's office and to CJS truancy. So when students meet truancy criteria, K through 8th grade, they go to the district attorney's office and CJSYS. That has given us an opportunity to kind of just pick up and move immediately and start reaching out to those families and making contact. When the district attorney receives that referral, that truancy referral, they have the opportunity, well, it's their opportunity to review and determine if truancy program would be suitable or if they would prefer to file a child needed care petition and bring that before the court.
All right, thank you, Kate, for that great information. So through our discussions and work, we have talked about doing this case management model. It's a tier model. So tier 1 is a model that will address universal issues. So it's available for all youth. Tier 2 is going to be targeted more for youth that need more intense services. And then tier 3 is sort of the bombshell that goes back to the district attorney's office where they will have to file a sync petition for the youth. So the program that we talked about doing is we've called it Everyday Counts. And basically what we want to do is provide immediate attendance support through case management services. Next slide, please. So basically our mission is really simple. We want to re-engage students. We want to support the families, and then we want to improve attendance outcomes. So for starters, in re-engaging students is getting that line of communication open with the family and the school district. We are going to provide, like Kate or someone would be at the school district, at their school as a friendly face for that youth to help get them reconnected and back in school and feeling safe to be there. And then we would be identifying who from the school district would be partnering in with that as well. We would be providing incentives to encourage attendance. And then another key thing is providing support to the families, finding out what those barriers are. Oftentimes we see transportation as a big barrier. If you don't live within, or if you live outside of 2.5 miles, you don't get a bus to ride to school. You have to figure out a way to get to school. So transportation, we would also be looking at things like housing, instability, if there's mental health concerns, et cetera. So we want to help try to bridge those gaps with those folks. Kate, would you talk about the K through 8 truancy flow chart?
Absolutely. Too bad. So the K through 8 truancy flow chart, I have copies here if anybody wants to touch it and feel it and look at it close up. So the student meets truancy criteria. And when that student meets criteria, the school will send out a warning letter to the parents. If there's no improvement or they don't hear from the parents, making that attendance right, then the school will send over the official 1006 documentation, truancy warning letter, and the attendance to the Douglas County District Attorney's Office and CJS truancy. Most times we're CC'd or on the same email. So tier 1 is of everyday counts is universal, which we will offer this to everyone that is willing to participate. It is voluntary at that time. And we're offering the parents to agree to participate. If we are unable to contact the parents or the family has declined, then we would take that back to the Douglas County District Attorney's Office and respectfully ask for them to send out a letter encouraging the family to participate in tier 2, which is more targeted to kind of assist the family with the neighborhood truancy board with building peace. So the hope for Building Peace is that this level of involvement will kind of engage the family and bring them in to hopefully resolve some barriers. If they are not able to contact the parent or guardian, or they've declined as well, then Building Peace will notify CJS and also the Douglas County District Attorney's Office to recommend that possibly a review for a child in need of care petition. And then that would be tier 3, which is intense. Some children need that level of support. We would have the district attorney review to see if they feel like it was determined to have a child in need of care petition filed. And then it would be scheduled before the Douglas County District Court, and they would have a formal hearing before the judge. The judge at that point, at a formal hearing, can make an order, adjudicate that child as a child in need of care for not attending school as ordered as the law, and can order them to either attend school each and every day with no unexcused absences. They could ask the child to participate in everyday counts. Building Peace can make recommendations to services with O'Connell Children's Shelter. So there's many things that they can kind of offer.
All right. Thank you, Kate. So, so tier 1, everyday counts. Like Kate said, this is the step 1. We receive the referral from the school district. We reach out to the family and we explain the truancy process. We talk about, we start to try to identify barriers. Then at this point in time, this is all, this participation is voluntary, so they don't have to do it. We encourage them to, but it's something that they don't have to do. If the family does agree, though, during that time, we will go over the program contract, and our program expectations are for the youth to attend 8 weeks of school with no unexcused absences. If they have an absence related to illness, then we would require that the youth present a doctor's note. I don't know if this conversation has already been had at the school district, if they require that or not, but so this may or may not be unusual for them to have to do. And then if this all goes well, then we would consider that a successful completion and would close the case without it going further to district court. And like I said earlier, we'd be providing case management support. So we would be meeting with that child and family individually. We'd be meeting with them at the schools, et cetera.
I got a question. Is there an approved definition of, or a standard definition of approved absence and unapproved absence?
It's up to the principal to make that determination of whether it's a excused absence or not. The principal can decide it's not excused, even if the parent writes a note.
That's something that we would be, so if we have a youth that is in our program and is absent, we would be communicating with that school to determine what is a approved or unexcused. Okay, so it wouldn't just be us deciding that, oh, you're missed school, so it's unexcused. We would be communicating with the school. Okay, so I'm sorry.
I had another question. I did flag this when I was kind of reading through the report about the doctor's note, which, you know, on one hand makes perfect sense. On the other, we know that healthcare is a barrier and a cost. And thinking of all the times that my kids stayed home sick, and I vouched for that we didn't go to the doctor because that wasn't what was needed, just needed to stay home and get better. And I noticed that it also said like, or a school nurse, which I assume would be a free access for nearly all, or would that be available to like all children in the school districts that we're serving? Just trying to think of that cost barrier and the hassle of getting a kid to a doctor when a parent is at work, et cetera.
That's a great question. So yes, the school districts all have their own nursing service that youth would have access to. And so by this point, the youth are missing significant time away from school. So
And I can answer to that a little bit. When we do have students who are, um, working with us, on like the Everyday Counts contract, we encourage them that if you are sick, please go to school, have the nurse assess you. And if they determine that you're sick, please utilize that. I identify with parents, I empathize with them, and let them know that, I know that it's down to the minute, and sometimes you can't get your child to the doctor. Please send them to the nurse to have the nurse assess them. Because
But if you have a doctor's note, that's perfectly acceptable.
absolutely. Well,
Looks like Commissioner Anderson has a question.
the principal would make that
Right.
determination.
Doctor's note would suffice for your program.
Yes.
But what if you don't send your child to the doctor because your child just gets better at home and you don't have a note, but your parents, says your child was home, it had a cold, boy or girl had a cold, and you sent them back to school, and then the principal went ahead and cleared them. But you may have another child that went to school and maybe had a cold, didn't go to the doctor, and maybe that child didn't get cleared by the principal. Maybe there isn't as good of a relationship with that particular family. So I'm just kind of curious about potential disparities that we're seeing here, because I see this 1 hour rule can count for the 357, and I only saw 24 on your list there.
As we said, there's a lot of underreporting, and I think maybe Katie could talk a little bit more about that. We're not talking about people that just come over that line. These are folks that are way in excess of that. So that's also important to remember here. They've missed days and days, weeks and weeks of school. So we're not talking about out of the gate. And maybe, I don't know in terms of the level of, do we have information on how far truant someone is on, how far in advance of 357 is it when it gets to the DA's office?
I mean, I have anecdotal evidence of, sorry. I just have anecdotal evidence of that. I would say that when Elizabeth and I pick up a referral, I would say most of them are, I look at it and I'm like, I would have filed that in August or September, and we're just now finding out about it from the schools.
Okay.
But I don't know what I don't know. 24 is what we've got, but I don't know how many we should have based on kids that are past 357, have gotten a letter and are still truant, probably many times 24.
But
Okay,
moving
so-
forward, that is a data point that we could begin to track, that what as the actual attendance rate at referral.
Okay. So when you say you're wondering that you're just now seeing it now, is that because you're seeing it in March, or you're seeing it in December, and the truancy started in August?
When they
Okay.
give us the 1007 that they've talked to 1006 that they've talked about, they also give us a printout of their attendance. So I can see the whole school year, and I can see all the, I don't know if you have a kid that's in school, but it's all marked by U's or E's for excused. But you can just take one look at it and see all the different U's of missing full days or missing fifth hour for every day. I mean, you can very easily see just from looking at the attendance that they were truant a long time ago, and we should have been able to intervene a long time ago.
I might just also offer that I think, some of the questions we're asking, and the commissioners are thinking about are outside of the control or purview of our role in it. And so I think that it's highlighting some, the underreporting has been mentioned, that the issue is larger than we can see based on the data that we have. But our role is to figure out, how do we make sure that once a referral is made, once that documentation is submitted to the district attorney's office and CJS, what are we going to do with it? How do we address it to make that program as successful as possible? And it doesn't, unfortunately, it doesn't really help us unpack or address any of the previous to that point in time issues, which I think are just a larger education issue on a statewide level, I would imagine.
So, so leading this is a good discussion that leads us into tier 2. So tier 2 is more targeted for the students that are at a higher risk of absenteeism. And it's going to be the ones that, that either have, agreed not to do EDC, the Everyday Counts program. It could be the ones that have done a program, but then our reoccurring absenteeism happens again. So just chronic absenteeism. And then it could be youth that are in EDC, but they're not completing the fulfillment requirements. So at that point, what we would do is we would notify the DA's office and let them know that we need to escalate to a tier 2. And they would then send a letter to the parents advising that they need to participate with our friends at Building Peace to start the neighborhood truancy board. That Dave, I'm glad you're here. So the neighborhood truancy board and what it does is it uses restorative practices and structure to bring families, schools, and community members together. The emphasis is accountability and support with support. So do you want to talk about some of this a little bit?
But just a little bit, perhaps, there are 5 of us that comprise the founding members of Building Peace, and we're all Kansas Supreme Court approved mediators. And some of us have several specialties of parent adolescent mediation. Some of us are domestic mediators. All of that comes into play. There's a lot of elements here as far as our being trained to work with families. And the part about this that needs to be noted is that this type of a meeting, because it would be public, would not be mediation, it would be facilitation. Because we will report back to youth services and to the DA as to the outcomes. And under a mediation, it would be confidential where we would not. The part that is confidential is when the facilitator from Building Peace schedules a neighborhood truancy board meeting, is able to contact the family and to get several volunteers who we're going to train specifically for this role. There's good conversation in which we're really seeking to get to root cause, what's causing it. We're seeking to find community resources that can be of help to these people. We're writing up an agreement to get them to commit to that and to sign off on an agreement that they will, and then we will follow up. The facilitator from Building Peace will follow up with that agreement. There's a lot of conversation that can occur in those meetings. That part will be confidential, but the agreement will be public. And that's where we get to apply the umbrella philosophy that Building Peace has, is that we are a restorative focused organization. We are seeking restoration. We're seeking redemption. We're seeking opportunities for these folks.
I have a quick question for Dave. I'm interested to understand how the restorative services, the connections that you're providing. I'm familiar that the Lawrence Public Schools provides some restorative behavior responses early on. How is that different? Because I think Commissioner Reed pointed out, there's a lot of interventions that have happened previously to before it's ever sent to the DA's office. How are we making sure that we're not repeating those things that have been done in schools at the neighborhood truancy board?
We can't be assured of that on our own, but what we'll be trying to facilitate is a conversation in a way that's less formal. It'll some of the barriers to some of the fear that parents place. Part of our job as mediators is to put people at ease, to be able to have conversations, and we intend to build upon the Douglas County Community Resources List and develop an even deeper dive community resource. We want to find every particular resource that we can find that we feel good about, that connect these people, and include that in the agreements. We want them to commit to that kind of thing too. I don't know if I'm answering your question exactly, but we think that the conversational aspect of it, and we even talked about, we had a working title of the Neighborhood Truancy Board. And when we began talking with Pam and her staff about this, I said, that was just a working title. I said, no, that takes the hard clinical edges off of it. to call it a neighborhood truancy board. So that'll be part of our building rapport is a big part of mediation.
Yeah, I think the name sounds great to me, but has there been any engagement with school districts? And is there anyone here from a school district? Is there anyone online?
I didn't
Didn't ask?
to
Okay.
prepare to be here, but I've had conversations with them and I wanted to make sure the commissioners were comfortable with this program before. But, so if you guys didn't like it, there's no point in updating them. So, but they've been engaged in the conversation and I think they're supportive of the work, but we know we've got a lot of underreporting that's happening.
So, I mean, if this is tier 2, right? And it seems like there's a lot that's happened between the actual unexcused absence and this point. I mean, a lot with the students I've dealt with, there was a lot that happened before they'd get to the neighborhood truancy board. Has there been any discussions of moving those kind of discussions upstream at all? And maybe there has, and that's just not part of our purview.
Specifically.
Okay.
Although we are having a separate discussion, building piece with the school board on a host of other things with some of the other juvenile services that we provide.
I can kind of help with that answer. So when the school does file official 1006, they are to complete that form, which gives us information as to what the school has done and to kind of like what steps they have put in place to kind of mediate the unexcused absences. It's always something that we can be more specific to ask. Has there been any restorative circles or any other restorative programming in place? What has the school put in place to avoid further truancy? So those are things that we can be tasked to kind of ask when we get that referral and kind of have that on our referral form, follow up with the schools and kind of inquire that as well.
But what initiates a 1006 if you've only had 24? What initiates a 1006?
Someone from the school district who is assigned to monitor children's students' attendance when they meet criteria. They send out a warning letter to the parent advising them of the concern for excessive absences or that they meet truancy criteria. When they do not come into compliance or they don't hear from the parent, that's when they initiate the 1006 form. And then that's when they send it over to the Douglas County District Attorney's Office with attendance, truancy warning letter, and a Form 1006. That's officially filing truancy in Douglas County.
Do you think that there are more 1006 forms filed and then the referral is just not made, or no? No. Okay. So the 1006 forms have not been filed at all. So the underreporting is just simply not happening. Okay. All right.
So I want to speak on behalf of principals, even though I'm not a principal
Yeah.
anymore. So there are lots of reasons kids miss school. There are many, many kids that hit the 357 that are not, they may be legally truant, but it is not a concern of the principal that they need intervention. You know, a kid could be late 3 days in a row, right? And first hour, that is a very regular occurrence, right? They are late so often, the parent will say, I'm not writing you a note. I'm not doing this. I told you to get up. You're not getting up. The principal may want to intervene in a way there before filing the 1006, right? A parent may have forgotten to excuse the app. That happens a lot, right? That the parent just sort of forgets to excuse the absence. Our principals have to weigh, when do we bring it to a referral stage and file that 1006? That said, I think I don't want to speak for Katie, but I think sometimes maybe we tried too long. We maybe should have gotten something in place earlier to sort of address absences. There's a lot of research on attendance and there's a lot of research on truancy. And if you don't grab it early and it becomes a habit, it's an issue. And yeah, so I'm just speaking up for principals that they have a lot and we want them to do that. If they filed every kid that was a 357, we would be hiring how many more attorneys, Katie? I mean, yeah, I mean, we'd have a lot. So.
Yeah, and I'm not suggesting that that is the case. I'm just trying, it's the chicken and egg, right? I mean, I'm trying to figure out like where is that spot in the system, right? And so which kids are falling through, right? The donut hole almost, right? And which kids need to be captured a little bit sooner so that they can be helped, right? Before December, November, right? When they need to be back in school and or are there, I'm also thinking potentially, are there some kids that maybe don't necessarily need to be referred? I don't know that answer. But I'm just kind of thinking about that.
Yeah,
In that, is there a gray area? I don't know.
well, there certainly is a gray area. And I think that's part of it. And also just, you know, we don't control what happens at the principal and the district level. And it's not, and we don't have data on that. It's not, and it's not consistent, but it maybe shouldn't be, because I think we have to allow that judgment to take place at the building level. And then when they're ready, when they feel they've exhausted all options, they know we're here. And then they know they can make that referral and then additional steps will be taken. But so, I mean, we can't control all the inputs into the system just because of the nature of the system.
Agreed. I think it'd be a great opportunity for the school district to be here. So, I mean, as thought leaders and policy governing body, for us to be able to have the conversation with the school district and to be able to hear from them where their pain points are, where the opportunities are, and where they're also having success.
We've been doing
So
that
we
at the
that we
staff level.
can celebrate that with
Yeah,
them.
we've been doing that at the staff level, and that's part of the conversations that we've had with each of the superintendents, and we'll continue to do that. You know, there's conversations that happen on this project annually. So there are conversations about truancy that happen annually.
Thank you. And I just wanted to just kind of wrap up the tier 2 part, and then we'll talk about the tier 3. So Lyle's group, or Dave and Lyle's group at Building Peace, will meet with the families 3 to 4 times. If they come to a successful completion, Building Peace will craft a formal closure letter for the family that will celebrate that success. If they don't, that's when we go to the tier 3. And Kate's going to tell you about tier 3.
Tier 3 is court involvement. It's intensive support for the youth. It's individualized. These are students who are needing the most support. And when cases reach this level, it's when families are declining services, and the district attorney's office will determine whether a child in need of care petition will be appropriate at this time. And there'll be judicial oversight, and that's when that process kind of begins. But this is the most intense kind of level tier for us to support that child. When the district attorney's office decides that they believe court is necessary, they will file the child needed care petition. The district court schedules a formal hearing. The child receives an appointed guardian ad litem, and that is an attorney who represents the child's best interest. This level of intervention is resource intensive for all involved, which makes tier 1 and tier 2 so very important. When they do have the formal hearing, the assistant district attorney and the guardian ad litem make recommendations to the judge, and the judge usually adopts kind of standard kind of services, like orders the child to go to school each and every day with no unexcused absences. He also adjudicates them a child in need of care for not attending school. And then the judge can order them to participate in any other services, which would be like EDC, Building Peace, O'Connell Children's Shelter, day school, So, if there's anything that other partners, think might be an option and we break that recommendation, usually they're open to ideas.
The anticipated timeline for a child that lands in this situation, because it's already been a long period of time before it gets reported to the DA's office and then getting through the 3 tiers. That's a long period of time. So how long are we talking about before? And if it took all 3 steps in order to get resolved, are we missing a year of school by that time?
That's a very smart question. And I think it goes to the importance of prevention on the school part. And it goes to when we get kids referred, we need to act right away and try and get them in short of filing a court case. Because I would tell you, if I decided today that I wanted to file a petition on a truant child, I would have to approach the court and ask for a court date. And I would assume that would be 5 weeks out at this point. So that's an additional 5 weeks of locking in this behavior with the child of, I guess I just don't go to school, and that's what I do now. And so that's a very smart question because that's what we see very much. And so to me, the earlier we can get intervention, that's why when the referral comes to me, it also comes to truancy services so that I can look at it and decide, do we need to file this right the second, or can we work on services and they can get involved right away?
And I guess that's, I'm looking at like the tier 1 and tier 2, like, could it be an either or, like which child, if a child would fit better in one path or the other rather than going through all 3? I don't know. I'm just kind of curious about how do we get the most moving forward fastest for these students as before they kind of get that really internalized.
That kind of answers to one of our slides about like who's going to be referred to the NTB. And those would be students that I've seen come through several times. I usually alert Miss Britton saying, hey, I've reached out, I've done a lot of work to get this family engaged, and I just don't feel like tier 1 is an option. And so those would be cases where I would send directly, to the DA to see if they can send over to building peace and engage at that level. So, there's some of those cases, yes. So we were kind of trying to find out like which would be those cases.
I'd also say, I think to your point, Commissioner Willie, I mean, ultimately, once that 1006 form is filed, the referral is sent to both offices and communication is open and begun. The DA's office has the option from that moment on to file a petition. So they don't have, I mean, there's still that waiting period because of the court's calendar and capacity issues to consider. But yeah, I mean, it does seem like on a case-by-case basis, the discretionary decision for whether or not a petition is filed and starts that court process lies with the DA's office. And I presumably in this program proposal would be a clear communication sort of both ways or collectively that really tier 1 and 2 are sort of no-go options at this point. It's severe enough, or like you just mentioned, straight to tier 2 because that's a choice. It's an opportunity. It's sort of a last choice, an option to offer, and if declined, being able to go straight to. So if I'm hearing correctly, like it's not that there's prescribed times to try tier 1 first, let that time run out, then try tier, that it is a little bit of case by case determining whether the option exists and is viable, or if we just need to escalate it to filing and begin that intervention, more severe intervention. Am I tracking that correctly?
Absolutely. Ms. Britton and I are pretty fluid with conversation. Like, for example, we have some students who were truant last year and we were not able to offer any services, either because they declined or we couldn't make contact with them, or a 1006 was not filed. Well, here we have it again. So then I usually show what efforts and let the school know what I've done, to let them know what we've done to kind of help get things underway. But I'll usually just alert Ms. Britton and say, I really feel like we need to start at this point in the process.
I think that's helpful to draw. And that was something that sort of stood out to me in reading the proposal, and is being clear that it read to me that discretion still exists and that there's not a prescribed step 1, step 2, step 3, that there's these options, and depending on the circumstances of each student and each family, one or some of those options may come into play immediately, and that the timeline is going to be different, and discretion will always lie at the center of that, and you guys won't be locked into this rigid plan that's not going to fit everybody. And so I think to draw it back to, Commissioner Kelly's commentary and perspective about principles and the sort of discretion that is important to respect and appreciate that lies there, and how circumstances can vary widely and we can't always apply the exact same rules. But it does seem like this is an opportunity, like on our end, to sort of clock that data point, at least from your perspective, in the DA's office, about being able to see like how long was the issue preceding, and that might just over time give us a better sense of where to identify some more upstream, some more earlier interventions, which I know is a continuous conversation, and constantly trying to figure out the ways to sort of attack that issue and all the ways that it manifests. But I do think that could be an interesting piece to look back at and determine, like, are most of the cases, by the time they reach you, it's been a pattern, at least on paper, it's been a pattern for months. And then what is the context that we receive from the school about all of that? So discretion is important in these processes. I really think that that's important to highlight, and that there are so many different circumstances for a student and family and things to consider, that I just want to appreciate that if I'm understanding right in the proposal, like that it won't create such a rigid process that we are sort of setting people up for failure or making the process take even longer, and that this hopefully helps cure some of that, opens lines of communications, and gets people on the same page more quickly about what the right next thing to do is.
So I know CSC used a volunteer model, community volunteers that kind of went into with the students and did some of that work. What's lost and what's gained by having that be a staff process?
Yeah.
Okay.
So this is what our estimated budget is for the truancy program. Oh, I'm so sorry. The estimated budget. NTB will be partially covered by the Kansas Department of Corrections Prevention Grant. And then we would ask for another juvenile services officer. Those numbers are on there, and that also includes salary plus fringe benefits. Okay. We would be asking for monies to help pay for incentives and barrier reductions. On the next slide, it kind of breaks it down a little more and talks about how like what fees Building Peace has. And we're looking at, this reflects really the potential for our building NTB referrals. And that's based on those who decline tier 1 services or who have been through tier 1 services previously. So this is a guesstimate. We estimate that 75% of those that would refuse, 75% of those that refused would participate. So, and that's what we gauge those numbers.
And just for clarity, the fiscal year 26 is half of a year and the fiscal year 27 is a full year.
Yeah, so that's going to be that last semester that Commissioner Dorsey was asking about earlier.
And we would have another juvenile service officer who would work alongside me to kind of help manage the caseload.
So we would lose that volunteer, but we would be adding in another employee to help bridge that gap.
And the model with the case management gives myself and the other juvenile services opportunity to focus highly on just case management and getting services in place. It says something when you go out to the public schools and special ed teachers recognize your face, and we all have a mission to support these youth and families. So it's good when you go out and you recognize people. I think that says a lot to what CJS offers Douglas County.
So that brings us to our next steps. Should the county commission approve our proposal, we would look at hiring a juvenile services officer in the summers. We get them onboarded and vetted and ready to start the August school year. We would identify the data that we want to collect. So this is good conversation. I made a note of that. That's a good idea. And then we would establish a school engagement plan. And part of that is just determining who will we be meeting with at each of the different schools? Who will the point of contact be for us at the school, and find that friendly face at the school. And then who from the schools should be attending truancy trainings. I know the principals do, but we also need probably the records staff, the ones that are tracking the attendance or whatever. So that's kind of where we're at this point. So we appreciate your time today, and if you have any further questions.
I got a question. I don't know who to ask it of, but what percentage are the parents at fault and not the student?
I'm looking at Kate, who has many, many years of experience with dealing with parents, and I think we probably both have an answer to this. To me, it depends on the age of the child. I think obviously the younger the child, the more it's a parent problem. The older the child, starting to get into middle school, it becomes kind of, depending on the case, a behavior problem with the child that's not then backed up by the parenting. So it totally depends on the case, but that's generally what we see.
That's right, Ms. Burton. It's kind of depends on the age of the child, but I really have a vision of wanting to go out there and bring the parents and get them involved. I want to be at their home, signing their child to a contract. I want to give them the tools to show how their child can be successful, and also how they can be successful in parenting this child and getting to school. So I just have a lot of ideas that might be helpful, kind of getting parents involved, and then also kind of having maybe like more of a team to reach out to weekly and biweekly to the schools, having that that person there that is the big advocate for that youth, somebody that they feel most comfortable with, and that being our point of contact. So engaging the parents a little bit more is my hope.
I really like what you just said, Kate. Like that vision seems strong, and I'm sure the schools would appreciate that kind of support. I agree with some of the comments by Commissioner Reed. I think I heard Sarah said that we have limits on our authority here in these spaces. But one of the things that we do is we fund certain programs, and that gives us some leverage in places to understand, are we just adding another layer of icing on the top of a problem, or are we actually getting to the problem? Are we really getting to it? And I guess what I'd like to see as you continue to work on this is I'd like to hear from school district officials saying, this is a really valuable tool for us, that here are some of the things we're doing now. And by providing this, whether it's mediation or whether it's somebody from criminal justice services being in our building, or whether it's somebody from O'Connell, or whatever that intervention is, that's the intervention that we're missing that we could really use to address truancy. These are the things that we're doing now. And for, if you're thinking about tiers, when we're talking about tier 3 kids, and I would argue on the tiers, all the kids that are been referred are tier 3, right? It is not all kids, right? So these are the kids that need the highest level of intervention, and we can't do it alone. We need the weight of the courts. We need the help of community partners. We need the help of criminal justice services. And so for me, that's what I'd like to hear, and understand. I know you've been working with them, and in full disclosure, I was at many of the tables on some of those meetings, but right now, what concerns me a little bit is that this is becoming a county thing that we do on top of as part of a criminal justice service. The district has set very clear goals about wanting to address truancy. So how is this dovetailing into what they're doing and a real need that they have?
Yeah, I think that's something we can continue to monitor and build on to the program with. That was part of the issue when we were working through CSC. There was a lot of complication. I think this streamlines the county's engagement, involvement in this process that the county's always had. And we can look to bring school district partners to the table and talk more about, keeping them engaged in this process. And if it's, and I had that conversation when we met with USD 497. I said, if you aren't going to use the program, we're not going to do it. It's something that, it needs to be valuable for the districts in order for it to be effective.
I have a curiosity to, what's most useful to the districts around, kind of go back to that question of, there was a model of bringing in volunteers that were kind of assigned to specific kids. So more variability, et cetera, than having a staff person, which can be well-known with the school and have that relationship, but isn't necessarily like one special person for one kid. Like, which model do they see being more helpful? And are there ways to, you look like you want to say something?
Well, I was just going to answer the question.
Go ahead.
Okay. They didn't really weigh in. I don't think I think they were excited. My understanding is they were excited about changes to this model. Gave more direct accountability they knew who to call. And so, but I think they also understand it's our program that we've created. So it'll be a change. I mean, we've always used more of a mentor model. So I think, but I talked to them several times and there were no objections expressed about moving to this model.
I'm still curious about, so we've got 4 school districts that are working within this system, one of which is partially in Douglas County and partially in Franklin County, in Jefferson County. So if a student lives in Perry and they're part of the Perry-LeCompton School District, so they live outside of Douglas County, do they then fall under our district attorney and our process? In the same way that we're saying that someone who's a student in Shawnee Heights is falling under the Shawnee County District Attorney and that process. And I'm
That's
curious.
I'd spent a lot of time on this very issue today for something else, but that gets to the issue of venue. I have venue here in Douglas County to file a case if the child resides here or if they are found here. And so I would say a kid that lives in Douglas but goes to school in another county, it could be in either. But I would say typically what's going to happen is that the school that they go to is going to report to the district attorney in the school's county. Mm-hmm.
And probably not the same level of problem over private school, but our private school is also covered by the program. Sorry.
Yes, I usually have contact with Corpus Christi. They reach out usually about once a year just to kind of check in to see how truancy referrals are accepted and always give them information. But normally that's the only private school that we hear from.
Thank you all for being here and for the information. Commissioners, any final questions for now that you have for this group of presenters? Okay, just a reminder that this is a work session, so no action is taken. Though I do want to acknowledge that our final slide that we went over does have some next steps. And so as I understand that, this is the opportunity for us to give feedback, ask questions, give any direction that staff might need around potential changes. So commissioners, if any of those thoughts are top of mind, we have a couple more minutes if you want to share that. Otherwise, I would expect that in the nearish future, we will have some business agenda items coming back our way related to specific approval of this programming. Is that accurate? I'm seeing affirmative head nods from our county administrator. So any final questions, thoughts, feedback that commissioners want to provide before we adjourn? Okay, and I will correct that. We are going to recess now until our 5:30 business meeting begins. Thank you all for being here.